Our next speaker is Dr. Michael Grewcock, who is Deputy Director of the Kaldor Centre for International Refugee Law. He teaches criminal law, criminology and penology at the University of New South Wales. Prior to commencing his PhD at UNSW in 2004, he worked as a solicitor and researcher in London for 13 years, specialising in criminal, prison and immigration law. And he also spent 3 years working as a legal and policy officer for the Howard League for Penal Reform, focusing mainly on teenagers in the criminal justice system. More recently, his research interests have included border policing and state crime. Border Crimes, Australia's War on Illicit Migrants is Michael's latest book, and he's co-author of the 5th edition of David Brown's Criminal Laws, of which the 6th edition is forthcoming. Thank you, David. Michael.
Well, I'd like to thank Heather Worth and the organisers of the conference for the opportunity and the invitation to speak today. These are clearly very important discussions. It's clearly very important for discussion of this type to be taking place, especially when the government is seeking to restrict the level of disclosure and public debate of its border policing policies. What's going on in our borders are not operational matters. They're matters of crucial importance for the entire Australian community. I was asked to speak about the human rights issues arising from offshore processing, which is both a bleak and potentially open-ended task. So I'm going to limit my comments to 3 main issues. Firstly, I want to give a very brief outline of some of Australia's formal human rights obligations that are relevant to refugees, and some of those have already been touched upon. Secondly, I want to discuss what I would regard to be the systemic breaches of these obligations, and especially those arising from offshore processing. And thirdly, and very briefly, more briefly than is probably helpful in some ways, I want to conclude with an alternative framework for responding to forced migration in our region. Now, Australia is a signatory to a number of human rights instruments that are relevant to refugees. Mostly, these go to issues of detention and forced removal. For example, Articles 9, 1 and 10 of the International Covenant on Civil and Political Rights prohibit arbitrary arrest and detention and require that all persons deprived of their liberty be treated with humanity and respect for the inherent dignity of the person. Similarly, Article 16 of the Convention Against Torture obliges signatory states to prevent acts of cruel, inhuman or degrading treatment. Article 37 of the Convention of the Rights of the Child requires that children not be subjected to cruel, inhuman or degrading treatment, that detention be a measure of last resort and for the shortest appropriate time, and that detained children should be treated with humanity and respect. Moreover, Articles 20 and 22 of the Convention of the Rights of the Child provide unaccompanied children or those whose family environment is unsafe with a right to special protection and humanitarian assistance. And you can draw your own conclusions from what you've just heard about how well those obligations are being met. Finally, Articles 12 and 13 of the International Covenant on Economic, Social and Cultural Rights provides for a right to enjoyment of the highest attainable standards of mental and physical health and a right to education. Taken as a whole, this snapshot of Australia's human rights commitments places a premium on individual liberty and personal security. It conceptualises detention as an exceptional measure of last resort, and it places expectations on signatory states such as Australia to promote such commitments and to ensure more than just bare minimum compliance. However, as the Australian Human Rights Commission, the Commonwealth Ombudsman, the UN Human Rights Committee, the United Nations High Commissioner for Refugees, various NGOs and parliamentary inquiries have documented extensively, there have been numerous breaches of these and other human rights standards by successive Australian governments for at least the past 20 years. Now, I don't have time to catalogue the various human rights abuses that have been identified, but I do want to suggest that they are systemic, that they arise from conscious government and immigration department policies, and that they are certain to be replicated, if not exacerbated, by the return to offshore processing that we have witnessed since August 2012. The systemic mistreatment of those seeking unauthorised entry into Australia in order to claim asylum is linked to the evolution of a border policing regime that has its most immediate origins in the introduction of mandatory detention in 1992. The main operational goal of this regime has been to limit and ultimately prevent access to Australian jurisdiction by those seeking protection from persecution in accordance with Australia's obligations under the 1951 Refugee Convention. Now, these obligations are quite limited. Although Article 14 of the UN Declaration on Human Rights provides for a general right to seek asylum, the 1951 Convention confines signatory states to two key commitments. First, Article 31 requires that refugees should not be penalised for unauthorised entry. And second, Article 33 prohibits refoulement or return to a place where a person might face persecution, typically, although not always, their state of origin. Now, successive Australian governments have interpreted these obligations very narrowly, if not ignored them altogether. Thus, when mandatory detention of all unlawful non-citizens was introduced in 1992, the then Labor government argued explicitly that one of its purposes was to deter further unauthorised boat arrivals. The obvious punitive impacts were either justified as an unfortunate necessity or deemed formally not to be punitive, a legal construction reinforced by the High Court of Australia in cases such as Al-Kateb in 2004, which held that indefinite detention was not unconstitutional because it was for administrative rather than punitive purposes, which wasn't much consolation to Mr. Al-Kateb. The profoundly abusive nature of indefinite immigration detention has been extensively documented. One of the most compelling accounts, and one which cuts through the dry legal reasoning of the High Court, was provided by South Australian psychiatrist John Gerardini, whose experiences of treating detainees at the Woomera and Baxter immigration detention centres were expressed to Senate committees in 2005 and 2007. And I just want to briefly quote from those two submissions. He's talking here about his first visit to the Baxter Centre, which is now closed, but which was purpose-built near Port Augusta. A man I have not met before invites me into his room at Baxter to meet his wife. Baxter was described as an improvement on Woomera: en suites, computers, playing fields. For this man, his wife and 3 children, there were 2 rooms, each a 3-metre cube with a bunk bed and just enough space to enter. I have never been in this room before. It is dark and I am disoriented. It doesn't feel right for a room to be so dark in late morning in the desert. As my eyes adjust, I see the man stooping over the bunk, a woman's face, eyes closed, but finally opening at his insistence. She looks around, frightened, and within seconds she is keening, half scream and half moan. It builds and continues unrelentingly. Her husband tries to quiet her, looks to me appealing, a little challenging. The moaning scream continues. I don't want to compound the harm that has been done to this woman, who has not spoken for 2 years, not walked for 2 months, who crawls to the toilet, is carried to the shower, screams when anyone but her husband approaches her, keeping even her children away. I leave and she screams on. A couple of years earlier, Dr. Gerardini had written to a Senate committee, a Senate inquiry into the Migration Act in these terms. The implementation of immigration detention over the last 5 years has caused severe psychological damage to detainees. I know of no other cohort where such universal mental ill health has been demonstrated. Parents have been crippled by their experiences to a point that they could not protect their children, and all children have been damaged by having witnessed frightening violence and adult self-harm. Most single men who have been in detention for longer periods of time are grossly damaged. And he goes on to conclude, better mental health services in detention will not help because the environment is so toxic that meaningful treatment cannot occur. It is not clear to what degree that detainees will recover, but some show significant signs of continued traumatisation a year after release. In relation to its non-refoulement obligations, the Australian Government asserts its compliance with Article 33, but regards it has no obligation to monitor the safety of those who have been returned after being refused refugee status. 2 reports by the Edmund Rice Centre at the Catholic University in 2004 and 2006 documented some 80 cases where asylum seekers returned by the Australian authorities, mainly from Nauru during the period of the first Pacific solution, to states such as Afghanistan or third countries like Pakistan, were placed at risk. In some of these cases, travel documents issued to returnees by Australian immigration officials were not accepted. In others, documents were confiscated or expired soon after return. More recently, there have been reports of Tamil asylum seekers being arrested upon being returned to Sri Lanka, not least because it is a criminal offence in Sri Lanka to leave the country without an exit permit. However, the Australian government's decision to give 2 patrol boats to Sri Lanka to assist their border policing efforts, and Australia's refusal to support even a US-backed UN resolution calling for an international investigation into alleged war crimes committed since 2009 in Sri Lanka, indicate the priority being placed on preventing unauthorised refugee movement rather than focusing seriously on its causes. Now, since the introduction of mandatory detention, Australian border policing has essentially gone through 4 phases. The first, the period in the 1990s, where we witnessed the consolidation of mandatory detention on the Australian mainland, which for all its shortcomings ultimately resulted for most of those who were detained in resettlement in Australia. The period between 2001 and 2007, the period of the first Pacific solution, where we saw the introduction of offshore processing on Nauru and PNG, and resettlement elsewhere, but again, despite the government's rhetoric, mostly people ending up in Australia. And then the period between 2007 and about halfway through 2012, during the period of the first Rudd and Gillard governments, mainland detention or detention on Christmas Island, various attempts to pursue so-called regional solutions such as the Regional Processing Centre on Timor-Leste, but again, ultimately resettlement in Australia. But then finally, the current situation, which we can date back to August 2012, the reintroduction of offshore processing and detention on Nauru and PNG, the excision of the entire Australian mainland from the migration zone, so even if you manage to turn up in a port in Darwin, you're not technically in Australia for the purposes of claiming asylum. And since July 2013, processing offshore on Nauru and PNG, and no prospect, no guarantees, or no undertakings there will be any resettlement in Australia. Now, the dominant narrative underpinning each of these phases is that the so-called legitimate refugees are those who arrive through resettlement arrangements, entirely on terms defined by the Australian government, while refugees seeking access by unauthorised means are to be penalised because of their means of travel. This not only denies the realities of forced migration, which is characterised precisely by the absence of orderly resettlement queues and authorised means of travel, but also fundamentally conflicts with the spirit of the 1951 Refugee Convention and the conception of a refugee as someone who, because of experiences and ongoing fears of persecution, requires protection from another state, regardless of their travel arrangements. The current cynical and myopic iteration of this narrative is that stopping the boats is necessary to prevent refugees risking their lives at sea. But those risks are generated primarily by the absence of formal migration options and the precarious circumstances in which refugees find themselves stranded in transit states such as Malaysia and Indonesia. Moreover, by exporting its obligations to Nauru and PNG, the Australian government shows little regard for the increased risks of personal safety that are associated with detention, removal or resettlement in those states, or the human rights records within those states more generally. In 2012, the Gillard government made the decision to return to offshore processing in Nauru and PNG, and in light of the High Court's earlier rejection of the so-called Malaysia swap deal, on the grounds that the Malaysian government's assurances were insufficient to fulfil Australia's human rights obligations, the Migration Act was amended so that the Immigration Minister can declare a country suitable for regional processing on the sole grounds that the Minister believes this would be in the national interest. In making that decision, immigration is not required to refer to international obligations or domestic law of the country in question. Instead, the Minister satisfies the assurance government's question the refugees will not be forcibly returned, and the consideration of their status as a refugee will be made in accordance with the Refugee Convention. However, the decisions to designate PNG and regional processing countries were made before any permanent facilities or legal processes were put in place in those states. In the case of PNG, the Minister made the designation before serious concerns raised by the UNHCR were even tabled in Parliament as required. And both the designations of PNG and Nauru for reasons such as those are being currently challenged before the High Court. Now, there can be little doubt that the key element of the Australian government strategy is to use the prospect of indefinite detention in PNG and Nauru, and the uncertain and possibly dangerous prospects of resettlement in PNG and Nauru, and now it seems Cambodia, as a deterrent to refugees seeking unauthorised entry into Australia. There is also a little doubt that Australia is only able to keep this regime in place because of its dominant economic and political role in the region. Nauru in particular, with a population barely exceeding 10,000 and its traditional income from phosphates exhausted, is heavily dependent upon Australian aid. However, while the Australian government is determined to devolve fundamental elements of its border policing and refugee determination processes to neighbouring states, it cannot absolve itself of the moral responsibility for the welfare of refugees under its effective control, nor its obligations under international law, even if there are limits to how international law is capable of holding the government to account. And there are a number of ongoing concerns which I want to look at. The first is the arbitrary transfer and detention of asylum seekers. Since August 2012, and again this has been touched on, any person who arrives is liable to be forcibly transferred, including unaccompanied children, even though the Australian government has guardianship responsibilities. As of the 30th of April, 1,177 people were detained on Nauru, including at least 190 children and at least 10 unaccompanied children. This plainly ignores the principles of last resort for detention, of treatment with dignity and respect, and arguably is a form of refoulement, especially in relation to PNG. Second issue is the access to Australian jurisdiction. For legal purposes, for the purposes of refugee determination and for obtaining a protection visa, there is now no access to Australian jurisdiction, despite asylum seekers being detained and transferred at the behest of the Australian government, subject to controls enforced and funded by the Australian and enforced and controlled by the Australian government, in clear abrogation of Australia's overall responsibilities. Thirdly, while both PNG and Nauru are signatories to the Refugee Convention, neither has developed refugee determination processes or mechanisms for implementing and monitoring human rights standards more generally. Procedures for assessing claims of those transferred by Australia were put in place after the agreements were signed to enable offshore processing. So far, about 20 decisions have been made on Nauru and approximately 25 in PNG. 13 have been accepted as refugees by Nauru and 11 by PNG. However, in PNG, these decisions are recommendations only. The final decision with the Minister has yet to be made, and there is no review at this stage by an independent tribunal or court. In Nauru, legislation passed in Nauru in 2012 provides for the establishment of a Refugee Status Review Tribunal, but it is difficult to envisage this being established in a country with such minimal infrastructure as Nauru without significant Australian input. There are clearly serious concerns about the standard and safety of detention centres, of poor living conditions and the adequacy of medical facilities, and again this has been touched on. I'm sure others will develop this later as we go along. On 26th of May, Fairfax Media reported a report by the International Health and Medical Services that approximately half those detained on Nauru and Manus Island were suffering from significant depression, stress or anxiety. There are also clearly concerns about the general levels of safety within the offshore detention centres. The worst example, as I'm sure you'll all be aware, arises from the events which took place on Manus Island almost exactly 100 days ago in February this year. 60 people were injured, including one man who had his throat and neck cut, allegedly by a G4S employee, and the death of Reza Barati after a rock was dropped on his head, again allegedly by a Salvation Army employee, and is subject of the Cornell report, which was yesterday released. Statements from detainees indicate that attacks by PNG indicate that the attacks were made upon detainees in the days prior to the killing by PNG police and detention centre employees. The Australian government, while it's commissioned a report which was released yesterday, has declined calls for more open and thorough judicial investigation, citing essentially this is a matter falls within the jurisdiction of PNG. Questions of whether prosecutions and so on are pursued are matters for the PNG authorities, and essentially Australia has no obligation to pursue the matter further. This reflects a wider lack of transparency, which again has already been mentioned by Gillian, in relation to the lack of information from the Australian government, the denial of access to PNG and Nauru, to the Australian Human Rights Commission and to the UN High Commissioner for Human Rights, and refusal more generally to grant media visas and access. It also highlights complicated lines of accountability between different governments, policing agencies and private operators, with the Australian government trying to distance itself as much as possible for direct responsibility for what happens within the centres. Finally, there are concerns over the nature and circumstances of voluntary returns, especially given the limitations of resettlement in states like Nauru, PNG and Cambodia. Compared with a wealthy developed country like Australia, the levels of infrastructure and general capacity to facilitate long-term resettlement are minimal. The immediate arrangements are still little more than provisional. In Nauru, those who have been granted refugee status will be issued with 5-year visas, but not even allowed to obtain tourist visas to visit relatives in Australia. In PNG, there are still no final arrangements. Those who have been recognised as refugees, assuming that they get the acknowledgement from the minister in PNG, remain in a secured compound. Cambodia, in the case of Cambodia, while we're still waiting for the release of the Memorandum of Understanding, which will broadly set the terms of any arrangement between the two governments, there are still major concerns about the overall human rights record in that country, including the forced return of Uyghur refugees to China over the past 2 years. In the 2014 World Report, Human Rights Watch described Cambodia as, and I'll quote, engulfed in a human rights crisis. Now, as Hannah Arendt noted in relation to the cumulative measures that stripped millions of Jews, Roma and other minority groups of national and civic rights in the 1930s, enabling them ultimately to be lawfully rounded up and for administrative purposes to be dispatched to so-called labour camps, the concept of inalienable universal rights only has meaning when individual states are willing to give effect to them. Now, while I'm not suggesting that Australian border policing policies amount to genocide, Australian governments nevertheless have deliberately sought to hollow out any sense of personal agency or legitimate aspiration from popular conceptions of human rights. Instead, by pursuing aggressively practices that dehumanise refugees seeking unauthorised entry, for example through the repeated use of labels such as illegals, the use of neutralising terminology, some of which I've used myself, such as processing, transfer and solution, and repeated denial of human rights abuses or obfuscation of investigations into them, successive governments have enabled the Australian state to strip unauthorised refugees of any inherent rights while bestowing upon itself the right to detain, transfer and process refugees effectively as powerless commodities. In this context, identifying and seeking to address human rights abuses remains an important, albeit increasingly challenging task. However, I would also suggest that there is a pressing need to develop an alternative paradigm for viewing and responding to forced migration in the region. And at a minimum, I would suggest that it comprises 4 components. The first is acknowledging that forced migration is an ongoing phenomenon with complex political and socio-economic causes that is not going to be policed or denied out of existence. Second, accepting that unauthorised travel is often a necessary and legitimate response to persecution, insecurity, and the absence of options for formal travel. Third, focusing on large-scale resettlement in Australia as the main vehicle for reducing the risks and precariousness of refugee populations, particularly those stranded in the region. And finally, enabling entry to Australia for the purposes of claiming protection under the Convention, dismantling the detention and offshore processing regimes that penalise unauthorised refugee movement and inflicting systemic physical, psychological harm on asylum seekers seeking entry into Australia. And by chance, in relation to that fourth point, Andrew Wilkie introduced a bill into Parliament today outlining essentially those elements. Of course, given the political realities and the attitudes of the Coalition and the Labor parties, the bill doesn't stand a snowball's chance in hell of getting anywhere in the Parliament. That doesn't make it any less important that it be debated and addressed as a matter of urgency. Thank you.